thank you very much to those who speedily produced this over the short adjournment. Because I was hallucinating after all. I mean, whatever I saw which said supplementary bundle, it can't have been an authorities bundle. I did take the opportunity to download it onto my computer.
Very grateful, lady. I'm pleased that you now are party to that business of having a supplementary bundle. My lady, in terms of commission amounts, there are references in the judgments to the commission amounts in each of the cases, and I can give you the references. In the Wrench 2015 agreement, it's £179.85, and that is core bundle, tab 21, page 262, at paragraph 3.
Thank you.
Same paragraph will give you a figure of £408.98 for the Wrench 2017 agreement. The Johnson commission is £1,650.45, and that's the judgment of His Honour Judge Jarman KC, core bundle, tab 9, page 146, paragraph 1.
Yes. And
Hopcraft, £183.26. Judgment of DDJ Morris, core bundle 36 at page 400, paragraph 12.
Thank you very much indeed.
My lady, I was deep into the case of McWilliam.
Yes.
And somewhere around page 96.
Yes.
And certainly was going to reverse slightly back into page 96. I think I may have got to page 98. Mm-hmm. The court may find it slightly difficult when you've sort of been given blocks of a judgment, and certainly invite the court to read through in order the relevant parts of McWilliam in due course, because it can be quite hard if I'm dipping in and dipping out. But can I just dip back to paragraph 38 at the top of page 96? I read out, on the basis of those facts, it's apparent that the task of the broker was to identify the lender willing to lend to these borrowers which offered terms most advantageous to the borrowers. I should carry on reading. That's likely to mean a lender offering the most competitive interest rate, but it could be other factors. Having undertaken to supply information concerning PPI, Norton's task extended to identifying an insurer willing to offer PPI cover in respect of a loan by this lender on the terms identified. There were other tasks too: inputting information gathered from the claimants into a computer system for sourcing loans, and processing, packaging and arranging the loan and PPI policy. I think that's all relevant, not least when we go on to where we were, which is paragraph 44, page 98, when in essence my summary, and Lord Justice Tomlinson is saying is that this is just like the position in Herstanger, when there's no particular advice or recommendation other than that which is being described, and there was nothing described in Herstanger other than being a broker. There were reference to implied terms, and then the Court of Appeal, Lord Justice Tuckey, considered it implicitly, as you see, between H and J. At the very least, Norton implicitly told the claimants, not even expressly, that the terms offered by money partners were the most competitive to which they had access. And then Lord Justice Thompson, references the quote from Lord Justice Tuckey, and then at paragraph 45 over the page, I note that in that part of his judgment dealing with the question whether informed consent had been given to the payment of commission, Lord Justice Tuckey indicated that the disclosure by the lender to the borrower that in certain circumstances it paid commission to brokers' agents should have been accompanied by a warning that its payments to the broker might mean that he had not been in a position to give unbiased advice. I did not, however, detect in Tuckey LJ's reasoning any indication that he regarded the circumstance that the broker was providing a recommendation or advice, if the broker did, as the crucial feature which justified the conclusion that a fiduciary duty had been assumed. This perhaps goes in partial answer to the observation from the court as to are we looking at an advice or recommendation case, and that's the analysis that Lord Justice Tomlinson gives, and then he completes it off with the paragraph 46 that I've invited the court to read and maybe read out myself before, so I won't read out again. just pausing there, there's no indication in this judgment that the borrowers were necessarily told that the broker was going to find them the product that was the most competitive. That's the use of the word impliedly as opposed to expressly. There's no indication in the judgment that the borrowers necessarily knew that there was a panel. And one of the issues which has been taken against the claimants is that you need to know, and I've already given evidence in relation to what the claimants did know as a matter of fact, but just looking at that as an issue of principle, our case is that it cannot be necessary in any event that the borrowers be told. And that is, otherwise, what would happen is a less well-informed borrower, less financially sophisticated, would be denied the relevant duty which a more sophisticated borrower would have and enjoy simply by virtue of their knowledge that people like this in situations like this go to a panel of brokers. See the observation of my Lady Justice Andrews, what my lady knows.
Yeah. Can I ask you this? I mean, it may not be the right time to deal with it, but one of the things that struck me is that, of course, in some of these cases, one's dealing, or most of the early cases, one's dealing with a situation where the broker is being paid a fee. And the broker, so as far as the consumer is concerned, the lender, the borrower rather,
Yes, ma'am.
is concerned, they know that for the services that are being provided to them of finding somebody, they are shelling out some money. It might be a small amount, but as with any form of loose concept agency, somebody who's undertaking to carry out work on your behalf or find somebody on your behalf, they've got a finder's fee of some description. And that's what made the taking of the commission all the more egregious, because you wouldn't expect them to be paid from the other source. But in this situation, are the claimants saying that they expected these brokers to do all these things free, gratis and for nothing?
Well, lady, the answer to that is no, and that was the factual evidence that I sought to set out at the outset, which was that
what they made their profit on the
correct, my lady.
on the sale, but this is extra to the sale.
Well,
This is something over and above simply selling you the car. So, broker makes a sale of on an HP basis of a car, gets his cut in terms of the uplift on the sale price.
my lady, yes.
But is that not in every case? I mean, in some cases, the client will pay cash, will have enough money to buy, and so there's no extra being added, no extra service in terms of getting HP.
My lady, if they pay cash, there's no credit agreement.
Exactly.
We're not.
Exactly.
There's no one to get a commission off. The case doesn't arise.
Indeed, Mr. Ware, but that's the point I'm making, is that even in cases where they're paid cash, they get their cut on the profit, on the sale. So what is being postulated is that irrespective of whether you have all these extra bolt-ons, these extra bells and whistles of acquiring a credit agreement, the perception is that the broker is not actually charging for these extra services. Got to be.
My lady, let's look at it slightly more holistically. The position is that out there in the real world are lots of people who can't afford cars, and out there in the real world are lots of motorists who nevertheless still want to get their cars off their forecourts and sold. And the deal that is struck, if you like, looking at it at large, holistically, is that the dealers recognise that in order to get their cars off their premises and into the hands of a member of the public who cannot ordinarily afford it, what happens is there is this series of deals that we've talked about, where the broker, contract with a bank lender, and so that is the alignment of interest. That's how they can't just say, well, if I sold it, because they don't sell their cars. Some people still purchase cars with cash, but a lot of people now do not purchase cars with cash.
So doesn't this at least potentially cut across your argument, which you made very clearly this morning, of separating this into separate chunks? because it might be said that you can't have it both ways and say, well, there's a person walks into a car dealership and then decides to buy the car but they can't afford it, and that bit stops. I'm paraphrasing what you said this morning, and then the dealer becomes a broker, and brokers a financial arrangement. And I understood that was a submission you made this morning, but this question highlights that perhaps it's not as simple as that.
Well, look, you have a set of facts which you can always choose to describe.
Yes,
like,
sure.
Understand that in different ways. The base facts remain that the forecourt price is settled. That then there is the stage of obtaining finance, and at that stage the broker is acting qua broker. The broker has its own collateral, incidental, ancillary, I don't mind what language is used particularly, interest aligned with that of the borrower, because that's how they get their car off the forecourt and make their profit. To me, there's no internal inconsistency in that analysis at all. That is materially the same as a broker who's paid on result. They want a result just the same, and so it's not a relevant or fair comparator to say, but if they paid in cash, because if they paid in cash is not the scenario that arises, and the brokers are taking advantage of the opportunity to promote and select finance via a lender of the broker's choice. I appreciate one can get lost in language and play games with the language, but that's I hope, a fair description of the reality of the position. My lady, just in terms of finishing off that point about which I made about otherwise knowledge would be such that a less well-informed borrower would be in a worse off position. There's a case called English and Dedham, which I've already referenced, and that's in the Supplemental Authorities bundle. Can I go to it, please? Supplemental Authorities 2, page 27. And I said I would reference a passage just above the one I then read out. The passage is E, so 27E. And this is where Mr. Justice Slade says, I do not think that a court of equity should or will allow the defendant to be in a better position than that in which it would have found itself if, before exchange of contracts, the defendant or Mr. Mead, that's his representative, had told the plaintiffs of the application, that was an application for planning permission, in the name of the plaintiffs, which had been made in their names, as I think he would or should have told them. And that's exactly right in our respectful submission, to home in on the fact that we're dealing here with an equitable remedy, all about what's fair. The next case that I was going to invite the court to go to was the case of Medstead, and that's in tab 8 of the authorities bundle. It starts at page 132. And at paragraph 2 in the judgment of Lord Justice Longmore, page 135, you'll see Medstead is a company registered in the BVI which conducts business as an introducing broker. And what it did was introduce the investors, who were professional investors, to a so-called, I think it's a second-tier provider, see paragraph 5, such as Colin Stewart, who then have the ability to invest in some rather clever derivatives with a first-tier provider. So, para 5, a second-tier provider such as Colin Stewart may engage in introducing brokers such as Medstead to find potential investors. Alternatively, it may be the investor who engages the introducing broker. And paragraph 7 sets out what contracts there were. You can see there was at least 3 different contractual relationships in play. a contract between, I'm going to call the second tier provider, if you like, the bank. They're not the bank, but it's the equivalent thereof.
Yeah.
So they've got one with another bank, but that's a detail. Secondly, there's a contract between the bank and the investor. And thirdly, there's a contract between the bank and the introducing broker. There was no evidence in this case of any written contract between the investor and the introducing broker. And that's why I made a submission earlier. There's no real indication of a contract in this case between the borrowers and the broker. And we can see that the clients were sophisticated by going to paragraph 30, page 140. And the effect of that, quite different from this case, as you can see in the judge's primary findings. So the role of the broker, Medstead, was to introduce them to a regulated financial institution such as Collins Stewart, who could deal with a first-tier provider. No other evidence of the relationship between the clients and Medstead. The clients were not paying a commission to Medstead, and so must have assumed that Medstead was receiving a payment from the financial institution.
Yes.
And he said later, there's no evidence of any advice or recommendation which Medstead gave the clients. These are wealthy Greek clients, as I recall. And this was a case in which, see paragraph 32, page 141, down between, well, close to D. But in this case, those factors cannot, to my mind, be determinative, especially if the judge was right to say, as I think he was, that Medstead at least impliedly represented to them that the terms offered by Collins Stewart were competitive. To the extent that at least the client's investors repose, to that extent at least, the client's investors repose trust and confidence in Medstead, and to my mind, that gives rise to a duty which can be legitimately characterised as fiduciary.
That's the wrong way round, according to your submissions this morning. You don't assume that there's a fiduciary relationship by reason of the reposing of trust and confidence. It's the other way round.
My lady, yes, to say trust and confidence is normally conclusory, but it's the Lord Justice Longmore essentially saying what he is saying in the next part of that same sentence as a fiduciary relationship.
Yeah.
And what he's doing is
he seems to be saying that there's a fiduciary duty because of reposing trust and confidence, which I was simply querying in the light of what you said to this morning.
Yes, my lady. I mean, what it is an effective shorthand because one can say fiduciary relationships about the duty of loyalty. And the duty of loyalty is all about trust and confidence, and so one can use these words and put them out there and say, well, I sense
well,
this.
I may have misunderstood your submission this morning, but I thought you had submitted that the reposing of trust and confidence flows from the fiduciary relationship. It isn't the grounds for assuming that there is one.
That's right, my lady. I'm just simply seeking to submit that Lord Justice Longmore can be taken to have understood all of this, and it's what I would call judicial shorthand.
Okay.
It's a sort of it's conclusory, but it's his. He could have used the words duty of loyalty, and it sort of answers the question, if you like, instantly. But that's what he's doing. But Lord Justice Longmore, with his wealth, I think he's probably been in the Court of Appeal for about 19 years by that stage. Could be taken to have understood what's involved vis-a-vis fiduciary duties, yes. And what Lord Justice Longmore is doing here is he is finding a fiduciary duty in circumstances where A, the clients are professional wealthy investors, so even though they are professional wealthy investors, and B, as I've set out at reference paragraph 30, where they also must have assumed that Medstead was receiving a payment from the financial institution.
Yes. Because
that's not what's critical. What's critical is if, and this is a back to rehearsal of the submissions I made in relation to law, but if you have a broker who assumes or is held to assume a responsibility in this way, intervening or interfering or such like in the business interests even of wealthy investors, to the extent that we see But,
Yes.
and that extent is, see at D, at least impliedly, not even expressly, representing that the terms offered by Colin Stewart were competitive. That suffices, even in that case. It did influence what comes in the section below, which is headed Scope of Duty. And that's because the investors were wealthy, the conclusion then reached is that it was not necessary for the broker to inform the investors as to the amount of the commission. But that's a separate issue. Very much.
And there was no duty to disclose the fact because it was already known.
Because they're sophisticated, they don't need to know that sort of thing. So it was held not to be within the scope, and I think there are sort of two ways of looking at. I think this is paragraph 42. If you go on to 144, sidebar by my learned friends.
Yeah.
So if you pick it up on 145, please.
Yes.
In the Herstanger case, so right, I'll pick it up small. As Bousted, I'll take it at the top. As Bousted and Reynolds say, if the principal knows this, he cannot object on the ground he didn't know the precise particulars of the amount paid. He can, of course, always ask, and if he doesn't like the answer, he can take his business elsewhere. Bousted and Reynolds does add that where no trade usage is involved, and no uses which are alleged in the present case, the principal's knowledge may require to be more specific. In the Herstanger case, the court held it did need to be more special because borrowers such as the Wilsons come into the non-status leading market were likely to be vulnerable and unsophisticated. The contrary is the case here.
Yeah.
Again, there's a lot in Medstead, and this case is far a fortiori to Medstead in terms of the imposition of a relevant, disinterested / fiduciary duty. Can I now please go to the Wood case, which starts, as you know, at tab 11, page 239. And can I pick it up at page 252, please? Well, 251, sorry. 251, para 13. As you saw, there was a payment in respect to the first loan and the third loan, but not the second loan.
Yes.
That was para 13. Commissions were paid. She, Mrs. Wood, did not know about them, para 14. Over the page, paragraph 16, the broker's terms of business were the same in both cases, and they provided, and you can see at C, we work from a panel of lenders, and then the E, we may receive fees from lenders with whom we place mortgages. Before we take out a mortgage, we'll tell you the amount of the fee in writing. That's super specific language, which is why this ended up being a fully secret case, because it says, before we take out a mortgage, we'll tell you the amount of the fee in writing. In other words, if we don't tell you anything, you can assume there was no commission. If I can then go on to the relevant findings, if you go please to page 271, paragraph 104. Although the judge asked separately whether this agency created a fiduciary duty, he essentially relied on the same factors for his conclusion that it did so. The broker was tasked with bringing to Mr. Pengelly the best deal for him on the market. Mr. Pengelly was entitled to the best possible deal that the broker could provide. And that's all implied. I don't think there's any indication of an express term to that effect at all.
Yeah.
And then in Wood, if you go to para 105, but go over the page between A and B, please. The broker did not just, this is quoting from the judgment below, did not just randomly source lenders, but selected lenders based on what Mrs. Wood said she was looking for. And that was then, that quote was then enlarged. If you go on to 274, paragraph 118, Justice David Richards said it's important at that stage to enlarge it, but it's worth having a look at now, please. The service provided, this is the quote from the judge below, the service provided by the broker was not merely an administrative service, it was much more than this. Its representatives visited and met Mrs. Wood on various occasions and discussed her financial needs and requirements with her. The broker did not just randomly source lenders, but selected lenders based on what Mrs. Wood said she was looking for. Again, it seems to me that when doing so, the broker must have been acting on her behalf. And so if this court is seeking a guide as to those circumstances in which the line is crossed, it's very clearly set out here. What constitutes administrative and what does not. If you then kindly go back to paragraph 106, so that's page 272. Further, the judge considered it was abundantly clear that the relationship was fiduciary. In addition to the factors mentioned above, he accepted Mrs. Wood's clear evidence that she trusted and relied on the broker to assist her in her attempts to raise finance. He'd earlier said that even where an agent gives no advice or recommendation, but instead simply proposes or arranges a particular contract, there is at the very least an implied representation that the proposed contract was competitive. References to the McWilliam and Medstead cases.
Yeah.
So that is again the clearest indication, one, that we're well over the line, the abundantly clear, and two, that it seems not to be necessary or appropriate to use the language of advice or recommendation, although there is something of a semantic issue going on there. But that simply proposing and arranging a particular contract, so it's not the question my lady, Lady Justice Andrews had asked me earlier, the more difficult question. It's because but it mirrors this case, or these cases, particular contract, that there is at the very least an implied representation the proposed contract was competitive. And then at paragraph 110, obviously I'm as I say, cutting parts out and don't intend not to allow the flow of the judgment to be absorbed in due course, but just for convenience,
I've already highlighted this paragraph, which is the key, isn't it?
It's really important. It's what I've described as cutting to the nub of the matter.
Yeah.
And I'll read it out if I may. In my judgment, both Marcus Smith J and Mr. Pickering were unquestionably correct to hold that on the basis of the broker's terms and conditions and on the basis of the findings of fact at first instance, the broker owed duties which engaged the law applicable to bribes and secret commissions. It was under a duty to make a disinterested selection of mortgage product to put to its client in each case. And to me, that is well worth the emphasis. To the extent that it is necessary, and this is where we read before, they're also correct to hold the broker with a fiduciary duty of loyalty, etc. But that's what Lord Justice Davis Richards, who clearly was fired up in this judgment to shake, see what comes out and distill, and that's the ultimate distillation. It was under duty to make a disinterested selection of mortgage product to its client in each case. Put a different way, if you make a selection of a particular product to a client, you will find yourself under a disinterested duty. All other things being equal, and certainly we've got all other things being equal here in spades. And Lord Justice Richards at paragraph 113 says, nonetheless, the terms are inconsistent with Mr. Lord's submission that the broker's only duty was to pick one mortgage provider and product without regard to the availability of better products. It is, and this is the next sort of identification of three factual circumstances here. It is the broker, not the client, that had access to a panel of lenders. And then in parentheses, and the clients undertook themselves not to approach the broker's lending sources at any time without the broker's authority. And the broker undertook to work from that panel should provide the appropriate product to meet the client's individual circumstances and needs. This necessarily involved judgment and choice on the part of the broker, and that is, we respectfully submit, Lord Justice Richards absolutely clocking this essential feature that lies beneath a disinterested duty and a fiduciary duty. As Mr. Pickering said in his judgment, the broker did not just randomly source lenders, but selected lenders based on what Mrs. Wood said she was looking for. And this then led the defendant to a plainly untenable position, see paragraph 114, which is put with some elan by Justice David Richards, because this is the submission that my learned friends are driven to, which is it's okay. It doesn't matter if the broker represents the least favourable deal to the borrower, making a maximum commission. It doesn't matter because it's an arm's length negotiation. It's just a commercial transaction, and equity has no place in this debate. That's the case that I am seeking to meet, and I meet it in part only with inviting the court to essentially adopt the observation of the court that submission lacks all commercial sense, indeed all sense. And then finally, Lord Justice Richards disposed summarily of what he considered to be a wrongly decided first instance county court decision, see paragraphs 125 to 126, called Pengelly, and they're called Pickup. And his reasoning here is also important. So I'm picking up in the middle of 125. At para 40, the judge had said that the broker in that case was not a whole-of-market broker, but had a restricted panel of lenders to whom they would refer customers based on what they considered best fitted their stated requirements, emphasis added. There was clearly intended to be an exercise of judgment on the part of the broker as to what best fitted the borrower's requirements, an exercise requiring an impartial and disinterested view. In my view, this was sufficient to impose a fiduciary duty on the broker in the limited sense in which that term is used in this context. That's a reference back to, you don't need a full panoply of obligations, and if you want to call it a species of fiduciary duty, it's a very specific one in relation to given role played, trying to find a neutral word, role played by a broker in respect of a single transaction. And it's because of those four cases that I make the submission that this court can have no difficulty in this case. Whatever guidance the court seeks to give, effectively guidance comes by the result as much as anything else. And sometimes too much guidance, as this court well knows, is treacherous and can lead to all sorts of difficulties later. But that's obviously entirely a matter for this court. So, my lady, in terms of comparing those findings to the facts of this case, obviously this submission risks being rather repetitive because essentially you have the case that I'm making by this stage. So I will try to do this in short order and to the extent that I'm getting any sense that's helpful to the court, because it may be that the court's already understood, whether or not understood the case that we're seeking to make. See the facts that I've set out earlier. The brokers arranged finance for the claimants. The claimants were financially unsophisticated. The brokers did so first by taking the claimant's financial details, thereby instantly putting them at the mercy of the brokers, in that the brokers knew just how much they could afford. It's very real, that. Imagine disclosing your own financial details in that way. The brokers then accessed a panel of lenders. Mr. Wrench was told this would happen, so also Mr. Johnson via the suitability document. All must be taken as having authorised that to happen. the brokers then selected a single lender from that panel, presenting this one deal to each claimant. I think one of the DDJs said it's a one deal, take it or leave it. And all of that is amply sufficient to found the disinterested or fiduciary duty. Mr. Wrench was expressly told that they would find in the best rate. That's merely an additional feature. Mr. Johnson was told in writing that they would undertake an assessment of best met his individual requirements. So we've now got express features additional to those that we see in the 4 reported cases. And anyway, in all the 3 cases, were inherent or implied in the broker's actions that in selecting a single lender, the proposed deal was competitive. And in this way, and in a very real sense, the brokers took an active role in the claimant's decision-making process in relation to the hire purchase agreement. Because you turn up, you can't afford the car, you give them your financial information, and they give you a lender. And you sign up. That sounds to me like the broker involving itself in your decision-making process, in spades. And that is exactly when the law imposes a disinterested or fiduciary duty, because it is not mere huff, then, for the borrower to contend that they are vulnerable to abuse.
You say it's blindingly obvious that in circumstances such as that, a less than scrupulous broker, of course no suggestion of that here, but a less than scrupulous, hypothetical, less than scrupulous broker could pick a deal which is plainly not the best deal on the table from the panoply of potential lenders because he's going to get paid a large chunk of commission.
My lady, yes, see para 114 of Wood.
Yeah. And that's the risk. Nobody's suggesting it happened, but that's the risk.
But we're not in a position at this stage. In relation to PPI litigation, we openly refer to PPI as the PPI scandal.
Yes.
And no one suggests that we were wrong to do so, or enlarging or upping the temperature or something of that nature. Now, we don't need to engage in that sort of thing, but this is a practice which I simply put that as a rider, my lady, to the question of how unscrupulous.
Well, there's also the incentive, of course, on the broker to, as you rightly pointed out, commercial incentive, to get the borrower to sign up because he wants to get rid of his car from the forecourt.
It's a feature that, in our respectful submission, makes this borrower more rather than less vulnerable. It's been put against us. One of the many arguments floating around out there is, oh, this is all different. It's all different in relation to the vehicle because you want the vehicle and so forth. Yeah, we want the vehicle. Absolutely. And you know how much we can afford. And if you give me something that I think I can afford, in that sense, I'm going to end up signing up. And what lies behind it, I don't know. And that's the world of secret commissions. It's exactly the world in which equity steps in. Exactly what it's all about. And that's why I've gone in some length to the, what, as I understand it, lies at the heart of the establishment of these relationships. And equity intervening, and I won't rehearse all of that, but that's why it's so important. And that is so plainly an exercise of judgment and discretion, not only because you can see it referenced as such, for instance, by Lord Justice David Richards in Wood, referenced expressly, but it's obvious it is. It's active. It's the word I use. It's active, not administrative. Or you can describe it as getting your hands dirty or getting your hands involved. Hands dirty is a bit of an equitable sort of phrase. I may not use that one, but it's getting...
Well, they're not really leaving it to the borrower to choose between 2, 3 or 4 people.
No,
although, in answer to a question from me this morning, you said that might even engage fiduciary or quasi-fiduciary duty. But in this case, we don't need to go there because you say, well, they don't get involved because effectively it's take it or leave it. Here's this particular lender, they're willing to give you this deal, sign on the dotted line, you get the car.
Fait accompli. Well, lady, that concludes issue 3, because otherwise I think I will be repeating
Yes.
myself more than I already have. Issue 4
Yes.
is addressing the question of whether the commission in wrench was secret or half secret.
Yeah.
And I've done some of the work in relation to this submission already, you'll be pleased to hear. This falls into two parts, one by considering the test to be applied, and two by application of the test to the facts in wrench.
Yeah.
And starting with the test to be applied, the first submission that we make, and actually it's not entirely clear to me, this is an issue from one sentence in Firstrand skeleton, but either way I've got to push my case and see where
Yes.
my opponent chooses to go orally, which is that the burden of proof is on the defendant to establish that the commission was half secret. And the reason we say that is that this is part of what I have called the knowledge and consent defence, and I've made submissions in relation to that already.
You say it's the knowledge part.
I do, my lady, and I took you to authority. I'm just going to take you to a couple of authorities on this now. I'm going to start with the Dun and English case, which I may have taken you to already this morning. It's Additional Authorities, Bundle 1, Tab 3, page 25.
Page, sorry.
Page 25, my lord.
Thank you.
25 of the first volume, not that it may matter electronically, but of the Additional Authorities. And if you, 25 in the first complete paragraph, starting that, which I'm afraid we didn't sidebar, but here it is. Now the first question I have to decide is, did he tell him so? According to the rule which I consider established, the onus probandi, that is the obligation of proving he told him so, lies on the defendant. This was in relation to, if you go back to page 24, Mr. Dunn, you see in the middle of 24, Mr. Dunn asserts that Mr. English did not tell him that he, Mr. Dunn, should have to sell the mine to Mr. English as one of the purchasers. I think they were in business together, and then Mr. English was up to his own mischief, as it would appear. And he, Mr. English, you can see from page 23, first sentence, stood in the fiduciary relationship to the plaintiff because they were partners in selling a mine. And so so essentially the defence was being run. You knew and consented to all of this. And the first question is, did he tell him so? And then if you go over the page, what you then get where we've sidebarred at 26 is, even assuming the defendant's version is correct, I must arrive at the same legal conclusion. It's not enough for an agent to tell the principal he's going to have an interest in the purchase or to have a part in the purchase. He must tell him all the material facts. He must make a full disclosure. And then again in the sidebar on 27, it must be proved that full information has been imparted and that the agreement has been entered into with perfect faith. That is, the agent must prove those things: good faith and full information. In a judgment of Lord Justice Stuart Smith the Younger, in a case called Trafalgar, Bundle 3 of the Additional Authorities, tab 42, page 1348. Under a heading, Informed Consent, at paragraph 42, Justice Stuart Smith says the defence of informed consent is only available if all the facts are disclosed that are necessary to enable the principal to fully understand the proposed transaction so that they may provide fully informed consent to it. In other words, there must be full disclosure of everything material about the proposed transaction. The burden of proving full disclosure lies on the agent. It all starts with the knowledge part of knowledge and consent. And not to be split up in some odd and artificial way. That's how this works in the submissions I made earlier today.
boil down to this. It's not enough to say you may be paid a commission. You've got to say I'm going to be paid a commission and how much.
To get a full defence, to negate the obligation. If you want to accept a commission as an agent when you would otherwise owe me duty, you need to give me full knowledge and consent of all the material, so I can consent fully informed to those facts. If you give me knowledge that you may be receiving commission, we're halfway there, and it's a so-called halfway.
So it's half secret, is it?
Or half secret case.
That's what I'm struggling with, Mr. Weir. I thought you were going to tell me what the test was for deciding whether it was half secret or
Yes,
full secret.
and I am seeking to know. This is it.
This is about the burden of proof. That's not the test for whether something is X or Y. This is about the burden of proof.
Oh, I'm sorry.
I'm probably being very
In
dense.
stages, Milan. Just on the burden. I'm just sorry. Forgive me. I haven't got to exactly the test yet. I've started. I'm on the burden of proof, and on the burden of proof, I'm saying that's part of the journey.
Yes. Okay.
So that's the burden of proof.
Waiting
My
on
next.
suspicion.
Well, I'm sorry, Milan. It is coming. My next submission is, in answer to the partial answer to that question, is it's an issue of fact. Now you might say yes, but nevertheless, it is an issue of fact whether the borrower knew that there may be a commission, not an issue as to whether a term as to the commission was incorporated into a contract between borrower and the lender. That's what I mean by an issue of fact.
What somebody knows or doesn't know is obviously a question of fact.
Yes, I know. That's why it sounds initially like a rather banal statement to say it's an issue of fact. But the point is, if we go to the judgment of His Honour Judge Worcester in the Wrench case, core bundle, tab 21, page 267. Paragraph 22. We say His Honour Judge Worcester was correct when he says.
I think he pronounces it Worcester.
Oh, I'm terribly sorry. Worcester. His Honour Judge Worcester. I respectfully submit that he's correct when he analyses at paragraph 22 that the issue is not whether or not the provision dealing with commission was a term of the agreement between the parties.
Yeah.
In many cases it will be, and the fact that the borrower has signed a relevant document will be practically conclusive as to his receipt and understanding of what it said. The issue in this case is whether by providing Mr. Wrench with a copy of the terms and conditions which included this term, secrecy was negated. This is a matter of fact. Yeah. Now, there's no respondent's notice to that. I'm not a particular fan of what I might describe as technical points, and I'm not necessarily saying it's a barrier to entry from then if he wants to challenge that, but I certainly it's not obviously been challenged to date. It's treated as an issue of fact in done in English, and when one's looking not just for the burden of proof but for the test, the language, and I appreciate the language is always to be understood in its context, but the language that we saw at page 25 in done in English was, did he tell him so? And if you then go to Firstrand, which is, if you like, the leading modern authority in relation to this issue. So that was done in English, Jessel MR, page 25 of the additional authorities bundle. Now the first question I have to decide is, did he tell him so? Mm-hmm. If we go to Firstrand, it's paragraph 35, tab 4, page 59. First of all, at paragraph 35, so we've got the same point about a question of fact. So, paragraph 35, what amounts to sufficient disclosure for these purposes? Bousted and Reynolds says, consent to the principle is not uncommon, but must be positively shown. The burden of proving full disclosure lies on the agent. I think this is an accurate statement of law. Whether there has been sufficient disclosure must depend upon the facts of each case. And then para 43 is when we get the question asked. So page 61, my lady, did it negate secrecy? I think it did. If you tell someone that something may happen and it does, I don't think the person you told can claim that what happened was a secret.
Sorry, where are you reading from?
Sorry, my lady, page 61.
Oh, sorry, page 61.
Para 43,
Yes.
down the bottom.
Yes, got it.
And again, you'll know it's actually the same language. So I don't know about test in the sense of the test is whether or not that person knew, and because we're looking not at whether something's incorporated into a contract, but we're looking at knowledge in a different context. We're looking at knowledge in a context of knowledge and informed consent. In other words, there has to be something real about it, because it's part and parcel of the sufficient knowledge that allows the borrower to provide their informed consent to what otherwise is a breach of the disinterested or fiduciary duty.
Is this all leading up to a submission that it all depends on whether he read it or not?
My lady, it's all leading up to a submission, if you like, that trying to cut to the chase, that if he read it or not and he didn't read it, but leading up is still important, my lady, because when one goes to the sort of principle, oh well, as a matter of contract law, if you signed it, you know, you're held
Well,
to
that's
it.
irrelevant. The question is actual knowledge. Actual knowledge depends on what you know.
Yes.
And if you don't read something, you might be taken to have imputed knowledge of it for the purposes of contract law, but that's not the point.
Well, my lady, that is my submission. I realise there's a sort of line that has to be drawn somewhere. For instance, sort of some sense in which if you sign something and it's in bold in front of you, if you sign on this page, if it is written in bold, there may be a commission, and you say, I didn't read that bit in bold and highlighted.
Well, you might not get believed.
Well, true, my lady. You might not get believed, but I don't know. Someone could be willful, I suppose, in that regard, and so there may be scope for some form of imputed knowledge in something like that. But where I'm trying to come from is the policy factor in relation to contractual terms being treated as parties being held to them is about contractual certainty, which is itself a good thing in the mercantile world. But what we are concerned here with is the law on bribery and secret commissions, and the policy factor is quite different, and it's very powerful. And we've given quotations, and Lord Justice David Richards has given quotations in the Wood judgment. We've given them in our skeleton argument, our first skeleton argument. And essentially, it's deeply corrosive to the commercial world. And so those policy factors are alive when seeking to identify where the line is to be drawn in terms of the knowledge which is required. Because what this is doing is negating what otherwise is very offensive to the law.
It's very offensive because it's secret.
My Lord,
There's a circularity to it.
I understand, my Lord, the element of circularity, but I don't think that, especially the policy factors, absent themselves because of being able to analyse it with the lawyer's
Well, you
mind.
say that, but I mean, let's say the contract spelled out exactly what the payment was going to be. Not just said there might be a commission, but said there will be a commission of £2,036 or £3.50 or whatever it was, all there. It's very hard to call that a bribe if it's written out in the document. That's from the perspective of the person on one side of the transaction. They're not keeping it a secret because it's there in the document. It's not, whatever it is, it's not a secret. Now, I understand in the context of consumer protection and consumer credit that you might say, well, they needed to have it drawn to their attention for the purposes of consumer credit law. I get that. But that's not what you're talking about. You're talking about a bribe.
My Lord, I'm talking about a situation in which, for instance, you could have a document, and this is small print enough. You could have a document that's 126 pages. You've got an unsophisticated borrower who turns up. It's hidden on page 124. It's even smaller than the rest of it. It even just to trick you, highlights different passages and says, please read all these other passages, but don't read this one. And let's just imagine that there was some sort of urgency. Your deal is good. It's not the facts of this case. I'm not saying they are the facts of these cases, but there was some sort of, if you sign today, everything's good, and if you sign tomorrow, all bets are off, and so forth. We're then in a world where actually it doesn't suffice to say, oh, it's in my contract.
Suffice for what?
For the purposes of negating secrecy, because that remains, as a matter of fact, secret to the borrower. It's in the contract, and as a matter of contract law, we address that issue. But as a matter of fact, between those two, between the borrower and the lender, that is secret, because it remains secret. It's so well hidden. I just got to exaggerate the facts to test the point, and have it 264 pages of documents, and so on and so forth, and even smaller print, and all the rest of it. Actually, it's not enough necessarily, until it then becomes a fact-sensitive mission in which I would readily accept, my lord, that the seriousness of secret commission liability is a factor, and somewhere it's in one of the cases that it's maybe in Herstanger, and no doubt my own friends will be taking the court to it. It is in Herstanger that's identified as an important, a feature that you've got to be careful because you don't just sling this liability onto people. But at the same time, it is an important feature to understand that we are concerned with the issue of knowledge and consent as a defence. So in other words, although there's a case law that says the sort of...
Is there a case you can show me in which someone has been found to have received a bribe in a context in which the bribe in question was written, the alleged bribe was written out in as much detail as you could ever need in a contract signed in advance? Well, I can't think of one.
No, my lord, but we don't have many half-secret cases. This is why Herstanger...
No, but this is about whether it's half-secret or fully secret. Your submission is...
Yes,
maybe I misunderstood you.
No.
What the problem is. But I thought your submission was that even if it was written out in full in the contract, it would be a secret commission, a bribe.
Well, my lord, I'm saying it all depends. That's why I've
I understand
given
you say it all depends, and you give extreme examples which are different.
Yes, and I can give an extreme example in the other direction, whereas my lady Alexandria's, either they're taken not to believe it, or I would can understand how.
But my question, just to be absolutely clear, what I'm trying to ask you, and it may well be my fault, I sincerely mean that. In a case in which the contract in question that was signed by one party has in it terms which set out in as much detail as one could ever wish the commission payment. Your case, as I understand it, but I'm not trying to put words in your mouth, is that if it could be established that the person signing that contract had not read that page of the contract when they signed it, it would be a bribe.
Well, I'm trying to make it. Court of Appeal favours the word nuanced in many circumstances. The Supreme Court even more so. But I'm trying to acknowledge that there may be, whether it's called inferences, imputation, constructive, or something like that, there may be circumstances in which that doesn't sit well. And just, in other words, to be able to, because
conceptually it doesn't sit well. That's the problem.
Yes.
I get completely the idea that whether you have knowledge of something usually is a matter that's fact specific. So I don't know. I may not know something if I don't read a document and it's on the face of the document. But when one's talking about the underlying policy of the law here, it's not the other party's fault that I haven't read the contract. And so they're not trying to hide anything. In fact, they're doing quite the opposite. Now, it may well be that there are circumstances in which you give an example, and I can see why you do in one of these three cases, where it's buried in the small print, and somebody's attention is drawn specifically to a completely different clause, and you're not expecting it to be there. It might be said, well, it's very difficult to see how that really is brought to his attention in any meaningful sense at all.
That's the essence, my lady, if I might respectfully adopt that sort of analysis.
That's the sort of point, but on the other hand, I see what my lord is saying about it, which is it's still not necessarily secret because it is out there in the open.
Well, it's not. the description in the open is, I would say respectfully, not fair, because that's in the open as a matter of incorporation of terms of contract being held.
Because you got my hopes up, Mr. Will. You told me you were going to give me a test. And so far,
My Lord,
you've given me examples on either side of the line, but I haven't given me a test.
Job satisfaction, my Lord, and not having a test articulated until this judgment forthcoming is exactly that. So it's, but my Lord, there's one, my lady, there's one more piece of guidance which I would invite the court to turn to, and that is in the Wood judgment, pages 274 to 275. And I'll take it through from 274, from 119 to 120, and hope to meet the submissions which are made against my reliance upon this passage at 120 by starting at 119. So just to sort of align, we're now in issue 2, which starts at 271. Did the broker owe a fiduciary duty to Mrs. Wood and Mr. Pengelly? So it's the existence of a fiduciary duty. We are not in issue 3, which you see at 275 before para 127, which is were the payments made in these cases half-secret commissions? And obviously we're interested right now in that issue. So I'm in, if you like, the wrong section of the judgment. And that's the first point that's made against me. And but then if we actually go to what happens, Mr. Lord, that's counsel for the defendant, also relied on the term that stated that the broker might receive fees from lenders as being inconsistent with any duty of loyalty. So that's going even further. That's saying it's in the contract. Mm-hmm. So there's an inherent sort of recognition or conflict. So how can I possibly owe you a duty of loyalty? And the first answer to that is that doesn't stand with Firstrand, and in which the broker was held to a fiduciary duty notwithstanding such a term. And further, for the reasons given with respect to the third issue, the broker's failure to make any disclosure in accordance with the term in these cases meant that Mr. Pengelly and Mrs. Wood were entitled to proceed on the basis, well, that's the detail of the clause. Yeah. So, and then he, Lord Justice Richard, says, I would also add that in my view, the broker could place reliance on this term only if it expressly drew the client's attention to it. And recognising that that is in the context of an issue, does the term negate the fiduciary duty, as opposed to is this a secret or half-secret case? Well, Justice Richard is saying, well, anyway, even if the term has been highlighted, it doesn't help you because of Firstrand. But by the way, before you can start relying on a term, you need to make sure it's expressly drawn to the attention of the customer. And that, in our respectful submission, is a general point that Lord Justice Richards is making. In other words, one that can naturally be transposed across to the arena of the drawing to a borrower's attention a clause for the purposes of knowledge and consent, as much as for the purpose of, is there a fiduciary duty at all? That's a required level of knowledge. Point. And again, it will lead to problems in the sense that expressly we then can hit the buffers of how expressly is expressly, and a rider that may need to be attached. See the observation of Lady Justice Andrews in relation to that, which to be fair, I would readily accept. There may need to be a rider, but the thrust of it is that it doesn't actually count as open just because it is in a contract, not open for the purposes of secrecy, because you can easily have it secret and in a document. Not least if, as I say, you smoke and mirrors and like a magician point someone in the other direction. That's, oh, I got it out, but the court doesn't do that. We're in the court of equity. It doesn't do that. It's a court of fairness. It actually tries to get to the heart of the matter. It's not process driven. That's my submission, my lord, my ladies, my lady, my lords, and I that's at least understood. So that's how respectfully we understand the test is or should be, in a sense of what we have is essentially we're waiting for the cases of Johnson, Wrench and Hopcraft, which will one would expect then articulate with as much particularity as the court felt comfortable or able to provide further guidance in relation to what I readily accept as not a straightforward issue. And on the facts, I've now taken you to the facts in Wrench, and I've taken you to the facts in Herstanger. So I won't repeat those, but I use them as a ready contrast, because Herstanger was a pre-contractual document saying, please read this carefully and sign it. This was a terms and conditions that's unsigned, which says please read clause 10, but doesn't say please read clause 12. In the context of a financially unsophisticated, namely therefore vulnerable borrower, and knowledge and consent is got to be real. Cannot just be mechanistic. And the burden of proof is on the defendant, and it is not, respectfully we say, being discharged. The next issue, issue 5, is why the lender in Johnson, and if Wrench is a half-secret case in Wrench, is liable as an accessory. And again, take this in two parts by considering the appropriate legal test to apply, which should be slightly easier to articulate, and secondly by applying the test to the facts of these cases.
So, sorry, just to finish up on the last
Yes, ma'am.
topic, are you saying that the commission was secret, or
Yes, my lady.
you're saying it's fully secret because buried away in the provisions that it wasn't something that there is knowledge of, or at least the defendants could prove that they had knowledge?
Yes, he certainly didn't have express knowledge. That's not an issue.
Yeah.
So there has to be
Constructive knowledge, if you like.
Exactly. I mean, exactly. Imputed constructive type knowledge. But that case is simple. It's in the contract, and you're bound by the terms of the contract, and you're deemed to have read them. And if you don't read them, that more fool you. I understand the case, and it's fairly put in that context, and it's not a straightforward issue. But that's the position we adopt when you understand that it's about knowledge and consent, in particular. That's how important it is. So it's not something that one simply rides over in that way by reference to the policy behind certainty in contract.
It might be said that the contract could perhaps have been written with the idea that it would negate secrecy, but allow them to make the submission that they're currently making.
Oh, perhaps. This is the trouble. You can say, well, we got it out there. We damn well know you're never going to read it. We got it out there.
Because
That's my 256 pages and tucked away. And
if they actually wanted Mr. Wrench to know, it would have been quite easy for them to tell him.
Just got to tell him. Just got to tell him orally. Ask him to sign a document like the Herstanger document and so forth. And that's the burden of proof. Lord, yes, that is our case. Issue 5, why the lender is liable as an accessory. In terms of the appropriate legal test to apply, we would accept that the test involves dishonesty. The case law is clear on that. We earlier relied on Herstanger, which does not reference dishonesty, and I'll come back to Herstanger if I may. So the payer of a half-secret commission is liable as an accessory where it has acted dishonestly in assisting in the broker's breach of duty. But in real terms, what that means is establishing that the lender knew of the agency, and that's again in inverted commas agency, knew of the agency in inverted commas, and knew that the borrower was not fully informed about the commission payment. Because paying a commission with such knowledge, not least when the lender is a commercial body, is objectively dishonest. And that is, if you like, chimes to some degree with the observation my Lord Justice Edis has just been made. So it's not necessary for the claimant to prove that Firstrand knew the broker would be in breach of fiduciary duty, it never is for these sorts of tests that you have to know that legally there's liability, and see also the twin sector case, which is in Additional Authorities, Bundle 1, tab 24, page 469 per Lord Hoffman. Paragraph 24, page 469. I do not suggest that one cannot be dishonest without a full appreciation of the legal analysis of the transaction. A person may dishonestly assist in the commission of a breach of trust without any idea what a trust means. It's well known that dishonesty is objectively assessed. I'm not going to rehearse that, which has been set out in Twin Sector and Ivy and so forth here.
Have you looked at there's a recent Supreme Court authority on accessory liability and the knowledge required for accessories. Lifestyle something. Lifestyle equals. I should know because I think I was in the Court of Appeal in that case, but just don't know if you've taken it into account.
Well, my lord, I'm not sure.
It may not be relevant.
Well, it may well be relevant. It may well be relevant.
It sounds like it might have something to do with what you're talking about. It's just when you were referring to the knowledge requirement, I think that's what the Supreme Court is
Sort of trying to explain Twin Sector, I think.
Is that in the bundle? No. But in relation to this issue, having set my stall out in response, what I'm going to do is allow my own friends to develop their case and then perhaps respond to it in my response.
I'm not giving anything away to say I will myself have a quick look. But
Yes,
I'm not doing your legal research for you.
Oh, what a shame.
I'm just telling you that I'm going to take a wee look.
Thank you, Bill. Well, it's very helpful, and apologies that we've collectively missed that one, and we'll have a look for it. So I'm not going to rehearse. I don't need to. It's in. I think this is. And then a friend, Mr. Hardwick's Scopus argument deals with all of this. The objective tests and so forth. I don't think there's any issue about that. But we would say that if we enter a world where more is required, then we also enter a world where Herstang was wrongly decided. And we say it was not. In Herstanger itself, Lord Justice Tuckey deals with it fairly shortly. So it's tab 4, page 59 of the Core Authorities Bundle, page 59. Paragraph 34. At B, a third party paying commission knowing of the agency will be an accessory to such a breach. And that's what initially the claimant had relied upon, to which I think needs to be added knowing that the borrower was not fully informed, or at least not knowing that the borrower was fully informed, if I can put it that way.
So can I just make sure, sorry.
Yes, my lord.
So we're talking about accessory liability.
Yes, my lord.
And the principal liability is a breach of fiduciary duty.
Well,
Except you
disinterested / fiduciary, but it's a halfway house case.
Yes. So what's the breach? It's not fiduciary duty. It's a disinterested duty.
Well, our case, I think that was my issue.
Yes.
1B or whatever. It is that the disinterested duty applies equally to a halfway house
Yes, I
case.
understand.
But if I'm wrong about that, it's whether you call it a species of fiduciary duty or an ad hoc fiduciary duty. The substance is the same. It's very much a bespoke duty that reduces down to giving the disinterested advice.
Yes. So the point of my question is, I think I know what being an accessory to a breach of fiduciary duty means in legal terms, because I know what the legal like to think I know what a fiduciary duty is, and I can imagine that there's accessory liability for its breach. But is there authority that shows that there's accessory liability which kicks in for breach of this disinterested duty?
My lord,
What's that?
No, my lord. The submission I made in relation to where logically wood takes us, I at one point hopefully prefaced by saying, it's well understood that you can be taken to a wealth of authorities, including wood, in which reference is made to halfway house cases and fiduciary duties. We're just saying that logically, from wood flows to disinterested duty, whether or not it's a species of fiduciary duty. So it's all new.
Yes.
Sorry, my lord.
No, that's right.
And there isn't therefore an authority that says disinterested duty applies in a halfway house case. We say it logically flows from wood, but wood wasn't a halfway house case, it was a fully secret case.
Yes.
And so there is not also a case that says disinterested duty then leads to accessory
I know,
liability.
and you're here to say there should be.
Yes,
I get it, I get that. But there also isn't a case, as I understand it, that says that an accessory liability can apply in a disinterested duty case. Or is there?
To be honest, I've not looked for one on the basis that when we have the term disinterested duty has been commonly associated.
Well, I understand. I know. I get it. I do.
Yes,
I get it.
yeah.
I understand. If your disinterested duty case is, and I'll say the word, merely a sort of quasi-fiduciary duty sort of thing, I get that. I can go back in my box and say,
Yes.
fine, I'm happy with accessory liability
Yes.
for breach of fiduciary
Yeah,
duty.
duty,
Because it's
yeah.
still a fiduciary duty. Get
Yes.
it. But you've at least floated the idea that it's not a fiduciary duty. It's something else.
I've been as careful as I can to.
And I'm not. I understand. I'm not criticising you, Mr. Weir. You've been
there
as
was that
careful. I get it.
sentence.
My question is, if
Yes.
I buy your argument
Yes, my lord.
that the disinterested duty is the applicable approach, and it's not a fiduciary duty, it's not a special funny kind, it's its own thing. Help me understand the case on accessory liability.
Yes. Well, I think the first answer to that is to say that I would like to come back to you on Thursday.
That's very fair. It has to be breach of some kind of equitable duty,
Yes,
doesn't
it's
it? Because
definitely
it's not
equitable.
tortious. I just been while my lord has been debating this with you, had a quick squiz at lifestyle equities and Armid, and that's actually accessory liability for procuring a tort. And what their lordships said is that you don't have to know that it's a tort, but you do have to know the facts, the essential facts which made the act wrongful.
Yes.
So you might find it quite helpful because, by analogy, if you know of the essential facts which make the act wrongful, you could be liable as an accessory.
That's what I'm trying to. That's where I've gone to. You know of the agency, and you know that there's not been full consent.
Yeah.
And those are the essential facts, as I understand it, and that's why I've sought to cut this whole thing down to those two issues. Okay. But you're right, my lord, that we should, and we will try to find a textbook or something to sort of substantiate or support the idea that we can apply accessory liability to something that may or may not be a species of fiduciary duty. I was actually trying to find again that sentence in Wood in which Lord Justice Richard said something like it may be fiduciary duty, but anyway, I'm not sure I can. 110.
If the making of the payment or the fact of the payment is the wrongful act, aren't both the person who makes the payment and the person who receives it principals?
Well, they're deemed to be principals in the world of fully secret cases.
Yes.
And so that's why, again, rooting out accessory liability in a disinterested fully secret case isn't going to happen, because that's exactly the answer.
Yes,
is you
that's
don't
what
need,
it says in Wood.
Exactly, you don't need accessory liability. And I don't know if I should have been more imaginative and then thereby contended that we don't even need accessory liability in a halfway house case. I mean, and there's a lot of fracturing of the law going on, at least by way of submission to my rights. And breaking things up and busting them and putting them back together again. I'm always reluctant to do more damage than is needed to be done to the fabric of the law. And at the moment, we've accepted that there needs to be.
I'm just wondering why it should be different as between a secret and a half secret. The point about that might be thought to be that they're both secret, but just to a different extent.
Yes, I mean, it's certainly put a different way. Even if we don't attach. Certainly, half secret is maybe better described as partially secret, because it's
something
not
is
necessarily
concealed.
half.
Something is revealed, but something else is concealed.
Exactly, my lord. My lord, may we reflect on that before I leap into the unknown and promote a case that I then want to back out of, which I'm very unkeen to do. And then it may be we're given permission or not given permission if we choose to be more ambitious in the scope of our submission. And the court will have to decide whether we're frustrating our opponents by doing so. But hopefully, my learned friends, one, nimble on his feet, and two, I'm sure he's nimble on his feet and able to adapt to any submission that may be made at a later stage. But for the moment, I limit myself to accessory liability. But with gratitude to the court for its more back to basics and that analysis there to try to shake the whole thing down. But on the basis we're looking at accessory liability, and on the basis that always the essence of these things in dishonesty and accessory liability is do you know the facts, and because you never have to know the law. You've got to understand the basics. It's a little bit like the Potter case, and that which is needed in relation to the limitation period, section 32. It's that sort of issue. Then we say it's knowing of the agency, and either knowing that the borrower is not fully informed or not knowing that they were fully informed. And applying that legal test to the facts of this case, Firstrand knew the broker had access to a panel, and I've taken you to, or no, I don't think I've taken you to this actually, but we can certainly see it in Wrench and Johnson. So in Wrench, it's the statement of Mr. Wood for Firstrand. So that's Wrench bundle, tab 2, page 28. I think I may not have taken you to this. Oh, yes, I did. It's paragraph 56. It was the one where Mr. Wood says the claimant didn't solely engage any of the dealers to find him credit, and the dealers only had access to a limited number of lenders on its panel. And he understands what it is that the dealer is doing, see para 55. The customer asks the dealer to arrange finance to help acquire a vehicle. In other words, the essential facts which in our respectful submissions suffice for the disinterested / fiduciary duty, what I'm then calling agency for convenience with inverted commas, are that the bank understands that the customer who's financially vulnerable is going to go to a broker. The broker is going to select or obtain his financial details, go to a panel of lenders and recommend Firstrand. And Firstrand knows it's going to pay a commission to the broker. It's going to pay a commission to the broker in circumstances where there is no indication at all that it understands that the commission will be known. What we've got instead is it's only on a maybe payable anyway on the contract, and then we've had a look at this is on the basis that then forms a part of the contract, as it does in Johnson or in Wrench. So we're not looking at saying it's not a part of the contract, but that's just a maybe payable clause, which isn't drawn expressly to the claimant's attention at all.
Well, Firstrand won't have any idea of what's in the underlying contract between the broker and the borrower, will they?
Well, my lady, I mean, there is no underlying contract between the broker and the borrower.
Yeah.
There's no underlying contract, and then I'm not in a position, because of, there've been judgments below and so forth, to start casting aspersions. But in relation to that which has been going on, but the idea that commercially it hasn't been understood that these are commissions which are going through. See the observation by Lord Justice Edis that I've put it into the contract, so I'm okay, but actually this system's working really well. Is risks naivety. These are the realities of how banks have been operating for a very long time in multiple industries, of which PPI was just one, and this is another. And this is not the only other one. And it's why these cases have assumed such importance despite the value of the commissions that you've heard reference to being so small. There are so many, because so many people do not buy their cars with cash. And that, my lady, is also what is known as taking the hazardous course of knowingly making a payment to the claimant's agent, not knowing if it's going to be disclosed by the broker or not. See Logicross. So if we go back to Authorities Bundle 1, tab 18, page 387. This is the judgment of Mr. Justice Millett. Then was 387 at the top, my lady. My one reservation which I make for the sake of completeness is this. It is clear that where one party to a transaction takes what Collins LJ described as the hazardous course of making a payment for the personal benefit of the other's agent and does not disclose it to the principal, he cannot afterward defend the transaction by claiming he believed the agent to be an honest man who would disclose it himself. Now we've got half secret, we're dealing with half secret cases here.
Sorry, I've better lost the reference.
Sorry, my lord, we're in Authorities Bundle 1, tab
Additional
18,
authorities,
page...
but additional.
Sorry,
Yeah.
we're in Additional Authorities Bundle 1. That's the mistake I made.
Logical.
Page, yes, my lord, page 387 at the top.
Thank you.
And although it references doesn't disclose it to the principal, and we're here in a sort of half-secret world, because that's what we're looking at for accessory liability, the principle remains. What you have here is a bank who, let me put it this way, has taken its chance.
Yes.
And the court holds people to that, especially commercial organisations, knowingly taking a position. Again, see the observation of Lord Justice Edis, it's not difficult to inform the borrower if you want to. You want them to be informed. The reference for knowing the broker had access to a panel, etc. in Johnson was Mr. Irving's statement, which is Johnson Bundle, tab 2, page 12. And that's, well, page 11 really. Starts at the dealer's role. So this is Richard Irvin, head of field sales for the bank at Motonovo. See para 1 at page 7, and heading the dealer's role. And then I won't read all that out, but you can see reference to arranging finance, to access to limited number of lenders, etc. So they know what's going on. I won't read all that out, but and all of that is sufficient in our respectful submission to found accessory liability and constitutes objectively dishonesty for these purposes. My lady, I was proposing, subject to, I don't know, ladyship's about to...
I'm not going to say anything.
Then I will close on issue 5, if I may, and open up issue 6. This is the last issue you will be delighted to hear, and I am currently way ahead of schedule. And that 1 o'clock break that my Lord Justice Edis is keen to allow him to put his skates onto meeting in his other capacity, I'm pretty confident as I speak on behalf of my learned friends, one that he's going to make. Issue 6, why the relationship between Mr. Johnson and First Bank was unfair within the terms of section 140A. This is just the Johnson case, only the Johnson case. It's a case in which the learned judge think it's on Judge Jarman, Casey,
Yes.
remitted it, but on a limited basis. I ought to take you to having referenced it actually.
You remitted it for some fact findings.
Yes, yes, for some I ought to root it out. It looks like it's.
I mean, at some point you're going to need to help us as to how we can sort of deal with that in
Yes, lady.
circumstances where the trial judge thinks that he can't make an informed decision as to whether it's unfair under section 140 without some fact findings,
Yes.
sends it back to the court for fact findings, and then we're being asked, if you like, to sort of leapfrog that in a way.
Yes, I mean, that's not wrong, my lady. And on the basis that it's sufficiently clear without any further findings of facts. And the reason,
Right.
and it's sufficiently clear because there are no findings of fact as counterweights. If you don't need to find a breach of conc in order for us to make good our case. There are no counterweight facts.
No.
It doesn't work that way under section 140A, and this is all part of what was analysed in a case called Smith and RBS.
Yeah.
Once expression I employed in that case was once you've poisoned a well, it remains poisoned.
Yeah.
Which may or may not be helpful to the court. But so actually, once you've got, and I'll come to the substance of the submission we're going to make, but we say that once you've got a commission of this size, you're done. And also, when we're only seeking repayment of the commission and interest, if we were seeking sophisticated further remedies by way of accounts or some such, or this wonderful concept of rescission and counter restitution, that might be that the court could say in response, well, I can't work out whether you're entitled to that because I haven't got all of the facts of the case. That's a possibility that it simply doesn't apply here anyway because of the limited remedy that we're seeking. So actually, we are seeking an outcome, my lady, however unpromising a start it is, when section 140A is to look at all the facts, and there hasn't been a particularly detailed fact-finding mission, or a fact-finding mission not been sort of satisfied. So it may be an unpromising start, but we say that it's sufficiently clear that the court can cut through it.
Right.
And that the order is at page 144 of the core bundle. That's the order of His Honour Judge Jarman, KC, para 4, remitting it to the DDJ to determine afresh the claim under section 140A to C, and in particular to consider whether conc, so-called, any relevant breach of conc. It's page 144, it's tab 8, my lady, core bundle. Page 144. Problem is, and I made this submission earlier today, if we don't appeal that looks like, well, we haven't established our case in relation to the size of the commission. If we're going to go back, that'll be treated by at a district judge level almost, well, that says in particular, but without any limitation, that'll be treated as can we establish breach of conc. If not, the inference to draw is we don't win. The halfway house, and we really don't promote this, the halfway house is to make observations in relation to the force of the case and then to have it remitted on all issues. But that really is an unsatisfactory outcome, and one that we simply say isn't required because it's sufficiently apparent that there is an unfair relationship. And the first and principal, well, we have two parts to our case. One is in relation to the size of the commission.
Before we get to that,
Yes, Lily.
Stupid question. It's because of the timing, is it?
I think so. It's fairly ancient, I think, this one.
Yeah.
Yes,
I said it was a stupid question.
no, it's not. But I think that is right.
So we're not dealing with the Consumer Rights Act. Okay.
Well, we've really got a sort of case in two parts. One relates to the size of the commission, and the other relates to if the court finds that there was a breach of the disinterested or fiduciary duty.
So the size is a point that you make complaint of, irrespective of whether it's revealed to you.
My lady, this is a half secret case. So what we didn't know that there was a commission, and we didn't know the amount of the commission.
No.
We only knew in Johnson
that there might be.
That there might be. I think it's clause 12.6.
Yes.
Commission may be payable by us for the broker who introduced this transaction to us. The amount is available from the broker on request. That's actually reading the second agreement, I think, at page 55 of Johnson. I think the first one might be a bit earlier.
Yes.
Yeah, but your lady understands that's the...
Right, so we're dealing with a partially secret case.
We are, my lady, and when we're going to come next to Plevin, and Plevin was a case in which the customer knew that there would be a commission, as opposed to maybe would be a commission.
Yeah.
So, my lady, the leading authority in relation to this issue is Plevin. And that can be found at tab 5 of the Core Authorities bundle, starting at page 64. That is a case involving a PPI policy, and I think one of the submissions which has been made against us is that in some way this should be limited to PPI policies, or at least shouldn't be applied across to this. That is, respectfully, not sustainable. It's absolutely apparent that Lord Sumption is engaged in general guidance in relation to the operation of section 148C of the Consumer Credit Act. And the relevant part of the Act itself, we also have in the core bundle, a core authorities bundle at tab 13, page 302. And it may be as well to start there. Appreciate that this is a provision well known to at least one member of the bench. Nevertheless, rehearse how it operates, at least in short order. So page 302, it really does exactly what it says on the tin. The language is deliberately broad, and it is to be applied broadly. And if your ladyship has reached page 302, the court may make an order under section 140B in connection with a credit agreement if it determines that the relationship, and both Lord Sumption in Plevin and Lord Leggett in Smith and RBS seek to emphasise that that's the highly unusual basis of the cause of action. I think unique, certainly not seen another cause of action which is founded on a relationship. Relationship between a creditor and a debtor arising out of the agreement, etc., is unfair to the debtor because of one or more of the following, and I won't read them out, but those are, as we'll see in Plevin, taken incredibly broadly. The A to C, including C, any other thing done or not done by or on behalf of the creditor, either before or after the making of the agreement or any related agreement.
You say it falls into 3, does it? Or does it?
C, my lady.
Yes.
And in deciding whether to make this is little 2, determination under this section, the court shall have regard to all matters it thinks relevant, including matters relating to the creditor and matters relating to the debtor. And that, I think, is the foundation stone for the submission. You can't possibly deal with this now. You need to make all the findings of fact available to you before you get started. But actually, there are no findings of fact that save a bank in these circumstances. But there are literally just none. There are no findings of fact promoted by way of skeleton arguments. It's a submission that's made, but it's hollow. And then if there is an unfair relationship, you go to 140B, and 140B gives you a series of discretionary remedies. and I should give you the reversal of the burden of proof provision. Yes, at page 305, 140b9, if in any such proceedings the debtor or a surety alleges relationship between the creditor and the debtor is unfair for the debtor, it's for the creditor to prove to the contrary. Now that doesn't mean you just allege, you have to allege the facts. So the claimant's got to set out the facts, but once the facts are set out, you then allege unfairness in the relationship, and the creditor has to establish why it's not an unfair relationship. And so if the creditors in this case had said, we've got all these facts that we want to rely on, which somehow brilliantly unpoisoned the poison well, that would be remission. We say that's just not this case. So, my lady, if you then kindly go to the judgment of Lord Sumption, it starts at page 67. But we've obviously referenced some of this in our skeleton argument, so I'm going to try to sort of leap through to the core section. And the core section starts at paragraph 17 on page 72, and you can see how we've sidebarred 17 through to 20. And I haven't done this so far, so perhaps I can try my luck now with simply inviting the court to read all of that, because I think otherwise it's a bit pick and mix for me to take out certain passages.
Do you feel you've sufficiently covered 10?
Sorry, my lady, if I suppose so. 10 has been sidebarred by my learned friends. I'm very happy for the court.
No, but I mean, it's a pretty well-known passage, but it deals with what 140A is designed to deal with.
Yes, my lady, yes. I mean, it's all important. I sort of gave my own version of a summary of how the act works, but very, very happy for you to read para 10 as well, my lady. lady, what in our respectful submission we can draw from that, at the end of para 17 you see reference to the sophistication or vulnerability of the borrower. And then this is a sort of numbers game in the sense that what we can see from paragraph 18 between C and D is a sufficiently extreme inequality of knowledge and understanding is a classic source of unfairness in any relationship between a creditor and a non-commercial debtor. It's a question of degree, such that there will be, if you like, a tipping point, and that's what Lord Sumption says, because you get down between D and E. At some point, the commissions, they become so large that the relationship cannot be regarded as fair if the customer is kept in ignorance. At what point is difficult to say. Wherever the tipping point may lie, the commissions paid in this case are a long way beyond it, and that was 71.8% of the premium. And last sentence of para 18, the fact that she was left in ignorance, in my opinion, made the relationship unfair. So it's the fact of and amount of the commission of itself renders the relationship unfair because, as he's described, there's too extreme an inequality of knowledge and understanding. No legal duty is required for that, see para 19, nor is it necessary for the claimant to go further than as Mrs. Plevin did between C and D in para 20 to say that, well, at D, the last part, her evidence, she would have questioned the commission if she'd known about it, even if the evidence doesn't establish what decision she'd ultimately have made. And that's why Lord Sumption says in the sentence before, had they done so, that's disclosed to her, this particular source of unfairness would have been removed because Mrs. Plevin would then have been able to make a properly informed judgment about the value of the PPI policy. That's what makes the relationship unfair. I don't give you the opportunity, the inequality of knowledge means I don't give you the opportunity to make an informed judgment as to whether you want to sign up. You don't have to prove you would not have signed up. You just can say you have confounded my ability to make a properly informed assessment. And all you needed to do, see the end of paragraph 19, to remove the source of that unfairness or mitigate its consequences, and see the observation, albeit in a different context, of my Lord Justice Edis, was tell me. All you needed to do. And the not needing classic causation is apparent both from paragraph 20 there and also from the Smith and RBS judgment. If you
Before you leave Plevin, Mr. Weir,
yes,
does paragraph 18 and the statement that Mrs. Plevin must be taken to have known that some commission was payable,
yes,
and the judge goes on bearing in mind she wasn't paying for their services, does that have a bearing on this half-secret, secret commission issue?
well, can I first of all just acknowledge
Certainly.
that part and say that is important, that even though she knew that much in the Plevin case, and now trying to take that and transpose it across. Well, I don't think it changes any part of what I've said. I'm just trying to see where it's being put into the equation.
Well, the point is, as a consequence of having listened to you very carefully in relation to secret and half-secret commissions
yes,
for a while, I then suddenly read a statement from a judge in the Supreme Court which seems to focus on the idea that Mrs. Plevin must have been taken to have known some commission was payable, and one of the key points is because she wasn't paying for their services.
Yes, my Lord, I've sought to...
Which chimes, all that's happened is it's chimed with something that I know I've been listening to.
Absolutely, my Lord.
Nothing cleverer than that.
No, absolutely. But that's why it's a fact-sensitive inquiry, and why I've taken the court at the outset to the facts, including the facts that each of the three customers understood that the broker would make its profit out of the sale to the lender of the car.
Right. Yes. Okay.
And that was, as I say, unchallenged. I've sought to make that good right at the beginning. Yep. So it's, in that sense, different.
It was much the same answer as you gave in response to a similar sort of question from me, not prompted by the Supreme Court.
My lady, yes, but I'm just trying to turn.
Yes.
Always got to go back to the facts of this case.
Yeah,
sure.
See Lady Justice Aspin and Ease and Conway. So that's our position, my Lord. In relation to the not needing to prove that sort of standard causation, because I think this point is taken against us as well. See also Smith and RBS, page 286 of the Core Authorities Bundle, tab 12, para 25. At D in para 25, Judgment of Lord Legate. On the face of the legislation, the court's discretion is entirely unfettered. It is, I think, clear that the court is not in these circumstances required to engage in the kind of strict analysis of causation, loss and so forth that would be required, for example, in deciding what remedy to award in a claim found on law of contract or tort.
No.
The commission in this case was, I think, 62.7% of the interest payments, and that is, I think, Core Bundle, tab 14, page 208. That's the judgment of the DDJ. Para 36, 62.7%, compared to the 71.8% in Plevin, described as well beyond the tipping point. The FCA redress scheme post Plevin had a sort of 50% tipping point for FCA redress. The comparator in this case is not the total payment under the credit agreement, because that includes repayment of the credit itself. It's the interest payable.
So the point is that although the way it's calculated was determined by taking the principal sum, the point you're making is that, well, that may be how it's calculated. Its effect is that it represents a sum equal to 60 whatever it was percent.
It does, my lord, and coupled with that, the commission was paid out of the interest. And you see that in the judgment of His Honour Judge Jarman in the Core Bundle at tab 9, page 153, paragraph 30. Mr. Butters, my learned junior, also today, next takes the points that the judge was wrong to find 65 and 65b, two of these issues, namely the commission was based entirely on the amount of the capital of the loan had no impact on interest. The lender's witness, Mr. Irving, accepted in cross-examination that the commission was paid out of the interest which Mr. Johnson paid. So that contrary to the finding of the DDJ, which is tab 14, page 207, para 34, in which the DDJ said, I find the claimant said this, which is, if I'd been told that the overwhelming majority of the cost of this agreement to me was just a commission payment to the dealer, I simply would have walked away. That's para 33. Para 34, if I find the claimant said this because he believed mistakenly that the commission had a bearing on the cost of the agreement. So if I've rushed this, it's page 207 of the Core Bundle, Judgment of the DDJ, paras 33 and 34. But he was right. It did, because it came out of the interest payments. And it's not trivial if you do a calculation of saying, well, how much of the interest was commission, and then you take...
He's right, isn't he, that the commission would have been the same if the interest rate had been 13%. Because the amount of the commission doesn't vary with the interest rate. You're right, I'm not challenging the point you're making that the money is paid out of the interest from the perspective of the car dealer and the bank, but from the perspective of the customer, the deputy district judge, I think is right, isn't he? In the last sentence of that paragraph, the commission would have been the same if the interest rate had been a different rate.
Yes, you can You can reach the same total figure for interest. I haven't done the arithmetic on that.
It can't be that complicated. I mean, if it's true that the interest, if it's true that the commission is paid on the capital is a percentage of the capital sum rather than the interest, then it's a statement of the obvious, if I could say so.
Well,
I mean,
whether it's 13%,
no. Oh, I don't know about that.
Yeah.
That doesn't matter.
No, you can increase the interest on the capital to get to the same ultimate figure. But what we're looking at is of the interest that was payable, 67 whatever it is, 0.3 or whatever it is percent, 62.7%.
My question is:
Sorry.
Is you're saying that it's obvious? As I understood it, Mr. Weir, what you were putting to me, at least the way it landed, was it's perfectly obvious, Judge. Don't worry. It's clear that the Deputy District Judge is wrong when, having observed that it was a percentage of the commission, the claimant must have been wrong, must have been mistaken, because the commission did not have a bearing on the cost. But the point the Deputy Judge is making is no, it didn't have a bearing on the cost from the point of view of the claimant. Why is it right? Sorry, start again.
Yes, ma'am.
Your submission is that paragraph 34, the Deputy District Judge's judgment is wrong.
Yes, the first part. Yes,
the first part is wrong because the Deputy District Judge was wrong to hold that the commission did not have a bearing on the cost of the agreement. And what I'm putting to you is, why is that?
Because the commission was taken out of the interest, so you can imagine a situation with no commission, you have less interest, and you have therefore a less expensive deal.
But that's the point the Deputy District Judge is making, that it's not correct. And you haven't explained to me yet why the Deputy District Judge is wrong in that respect.
It's absolutely my fault, Mill. I'm really I'm missing this point completely, I'm afraid, because I'm trying to look at it.
The point it's
through a
true
clever
that
lens.
the amount of money which the bank or the bank would have received would change, but it isn't. But at the moment, I'm not satisfied that it's wrong to say that the cost to the customer would have changed.
I can't remember if it's Johnson or another case in which there's a great big line of cross-examination, and we may have to try and root it out. It may not be Johnson, I'm not seeing it in this bundle. In which the barrister sort of keeps saying, essentially, as I understand it, essentially this point to the witness along the lines of, you know, you're happy to pay this. Look at the APR. You're happy to pay that amount anyway. Stop complaining.
That's a different point, Mr. Weir.
But is that a different point?
Yes, I think so. I think it's.
I'm not trying to
not very
diverge from this. I'm just
the question is whether the amount of the commission has a bearing on the cost of the agreement from the point of view of the claimant. That's the question. You've said the Deputy District Judge was wrong because the cost of the agreement to the customer is affected by the size of the commission. And I'm putting to you, what I'm trying to explain to you is I don't see why that's wrong at the moment.
well, in one sense, I'm somewhat less interested in.
Okay.
I'm struggling with sort of comprehending. It's my fault, and I no doubt be put straight by the learned juniors later.
Yes. Well, let me just try one more go. So the cost of the car is £10,000. Say, I don't know what it doesn't matter. The cost of the car is £10,000. The cost of the agreement, from the point of view of the customer, is the cost of the car plus the interest. That's what the cost of the agreement is. Only ever that.
Plus licorice also.
Plus licorice, whatever. Yes, but for the purpose of this discussion, it's the capital 10,000 plus the interest. That's always and only whatever the cost of the claimant is. Because the commission is calculated by reference to the cost of the capital, the commission never changes depending on the interest rate. So the customer never pays a different amount.
Yes, my lord. That's why I'm
I'm
hoping to answer it, perhaps sideways or obliquely, but by reference to what you see in cross-examination, because I understand that to be the essence of one of the points which was made by my learned friend in relation to APR. which he says, you've seen the APR, you were prepared to pay that amount of money, stop complaining whether something's going internally, if you like, by way of commission, which I understand to be my Lord's point. Don't worry about it. It's just in terms of what you were prepared to pay, that's what you were prepared to pay, which is perhaps the understanding of the commission would have been the same if the interest rate was 13%, or that's a sentence in isolation I'm struggling to understand.
Right.
The answer to that, repeatedly given by one of the witnesses at least, is you don't understand what I'm complaining about. What I'm complaining about is I'm really hacked off that I've been paying out money which has been going on a commission to a broker who never really told me about it. It's fully secret or half secret. And all I'm seeking to do, my Lord, is to draw it back to what Plevin is about, and that's what Plevin's about.
I know, but what you're actually trying to do is invite this court to overturn the judge's assessment of the witness. Because that's what's happening here. The judge in paragraph 33 and 34 has recited some evidence given by a witness and decided that it was given mistakenly because of a belief that the witness had as he was giving that evidence about something. And that's nothing to do, if I may say so, with Plevin. It's nothing to do with the Consumer Credit Act. It's to do with the basis on which the judge is deciding not to accept some evidence.
My Lord, my only response right now is at 4 minutes past 8 is that as you not be repeatedly punch drunk, I have the opportunity to speak to my learned juniors overnight and come back with a splendid answer.
Of course. I couldn't possibly.
Well, given that it's 8 minutes past 4, we have some sympathy with that. So
Absolutely. I'm sorry to.
No. But I think your Lordship's well, obviously your Lordship's taking a valid point, which is that if we're here to say that in the face of the judgment, nevertheless, this court should essentially reach a conclusion, then it's an important aspect of that to actually analyse which parts of the judgment is consistent with and which parts it's inconsistent with. And may I please give you my answer tomorrow? My lady, I wonder if that's the convenient moment, because I'm not going to finish by 4:15.
no, well, I'm not going to make you. We are well ahead of schedule.
Well
I
ahead.
think we're all getting scrambled brains at this hour of the day, so thank you for that.
I think everyone except my Lord Justice Birss
Well,
just warming up to the theme.
all right, well, I'm just speaking for myself. So we'll say 9:30 tomorrow, please.